worse to litigation involving allegations of sexual harassment, hostile working environment, or retaliation. Today, Donald and I want to talk about why there's such an increase in office romance, the positive aspects of office romance, the dangers of office romance, and the types of litigation that can result from office romances. And we'll give you 10 tips on how to handle office romances in your workplace, from designing a policy to taking steps to handle a relationship if it gets out of control. Let's get started. The first slide I have up here today is describing a changing workplace. For the last several decades, the workplace has changed. People are working more, working an average of almost 8 hours a day. And the fact is that Americans are spending more waking hours at work with their colleagues and coworkers than they spend at home. Plus, there are more unattached people in the workplace. Americans are marrying later in life, and people in their 20s and 30s are still part of the dating scene. Add these facts to the fact that females now make up over half of the workforce, and you end up with all the ingredients for a singles bar, usually without the alcohol, but even the alcohol gets added in some company functions. Next slide, please. Is there any wonder that the old taboos of workplace and romance seem to be disappearing? 51% of employees surveyed on the subject admit to having an office romance. And surprisingly, 29% admit to having sex in the workplace. If employees are planning and actually having sexual encounters in the workplace, chances are that not much work is being accomplished. However, to balance this fact, consider the fact that 10% of the people surveyed met their spouse while at work, which is something most people would consider to be a positive byproduct of office romances. And many individuals handle their dating relationship professionally and do not let it spill over into the workplace. Due to the problems office romance can cause, some companies try to outlaw all workplace romance, but it's very difficult to do so, and this is not what I will be advising you to do today. I'm going to try to convince you that not all office romance is bad, and to support that fact, my next slide tells you who our most famous couple who met at work is. It's Michelle and President Barack Obama. They met while he was a summer associate and she was his supervising attorney. Supervisor-subordinate relationships are some of the most problematic types of relationships for employers, but it appears, as Barack and Michelle demonstrate, that at times those relationships lead to long-term, stable relationships and can be a good thing. On balance, as employers, I think you need to allow but manage office romance. So I want to summarize the good aspects of office romance for you. Remember, the workplace can be a good place to meet people. Employees can be anxious to come to work and to even excel at work if they are trying to impress a coworker or a potential dating partner. Office romance, if handled correctly, may actually help office morale and productivity. And again, as we have already discussed, at least some workplace romances result in long-term relationships and marriage. And now for the dark side, I'm going to turn it over to Don to summarize the problems that can result from office romance.
Thanks, Denise, and welcome everybody. So yes, I get to start with the downside, the negative aspects of office romances. And you know, we will be discussing the types of employment litigation that can arise from office romances. But short of those employment litigation matters that can arise, there are also negative practical consequences associated with romantic relationships in the workplace. For one, there may be a decrease in performance, not just by the participants in the relationship, but also with respect to their coworkers. Their office romance could lead to damage to the morale of the workplace, a cut in productivity, The simple speculation and gossip surrounding a potential unknown, or at least not out in the open, relationship between coworkers can detract from the performance that an employer would typically want to see from its employees when they're engaged at work. Another practical negative consequence is favoritism, whether perceived or actual favoritism. Employees may feel that the benefits are being extended on the basis of sexual favoritism as opposed to merit and hard work. Another negative practical consequence could be, again, actual or just perceived retaliation. For example, when the relationship goes south, there may be retaliation by one against the other former sexual partner. But even when the relationship is still good, alive and well, there may be retaliation in the workplace in any event. That retaliation could come in the shape of, for example, the mistreatment of one of the partners to the sexual relationship by a third-party coworker, and then the other partner to the relationship retaliates against that coworker, takes action against that coworker's employment or things of that nature to protect his sexual partner. Other practical consequences not listed on the slide could involve employee turnover. When the relationship ends, one of the participants in the relationship can decide that, they don't want to show up on a daily basis, 8 hours a day, and be in the work environment with their ex any longer. And then, of course, from time to time, these relationships in the workplace can involve either one or both of the participants being married. And so you have the impact of that both outside the workplace in terms of, in some states it's still adultery and there's criminal aspects to it, but also the civil aspects related to that and the impact on those marriages and how that impact on those marriages trickles into the workplace, either by that non-employee spouse and their impact and what they do or don't do in conjunction with the workplace, and then also with respect to any actions that are taken outside the workplace between that estranged spouse and the sexual partner of the married participant to the relationship. And then, of course, you have the last point on this slide is the litigation that could arise from romantic relationships in the workplace. This litigation can arise from the actual parties to the relationship itself, or, as we'll talk about, coworkers may bring litigation based on the romantic relationship in the workplace. So now let's talk about what kinds of romance lawsuits you may anticipate in the employment context, because my understanding, you're all either HR professionals or those who are practicing labor and employment in some shape or form. And so the first type is what we've all been dealing with for decades now under Title VII, sexual harassment claims based on use of power or coercion by a person in authority to initiate or continue the relationship. Well, that's just a lot of words for what we all have typically come to call or has been considered as quid pro quo sexual harassment. But beyond that, there's another category of claims that may be brought against the company, and that's the paramour favoritism claims being brought not by the participants but by the coworkers in that work environment as a result of the romantic relationship in the workplace. Now, isolated paramour favoritism claims are not actionable. Favoritism toward a single love interest, the paramour, is lawful generally. Paramour favoritism disadvantages all employees who are not the paramour, both female and male alike. As a result, it is not based on gender discrimination. For similar reasons, discharging an employee for complaining about favoritism towards a paramour is not unlawful retaliation. That underlying complaint is not about conduct reasonably believed to be unlawful under Title VII, or for that matter under state similar laws. However, the paramour favoritism may rise to a level where it could constitute a hostile work environment. That is when the paramour favoritism becomes so widespread in the workplace that it sends a message through the workplace that sexual favors are an unspoken job requirement for job advancement. So even if not asked for sexual favors, employees working in such an environment permeated by sex may be able to prove a hostile environment exists. So let's put these litigation principles to test, and Denise and I are going to discuss 3 cases to give you a glimpse into how these relationships can find their way into the courts. The first example is the Sloane versus Acadia Realty Limited Partnership case, and that's a case out in New York, and it involves participant claims. In this case, the plaintiff was a senior vice president, director of property management. He had an employment agreement with his employer, Acadia, for enhanced severance benefits if he was let go or otherwise his employment ended without cause. That director, however, the plaintiff, engaged in a sexual relationship with his administrative assistant, who was also his direct report. That relationship violated the company's written sexual harassment policy, which expressly prohibited sexual relations between supervisors and subordinates. The facts in the case show that the plaintiff received training on the policy that prohibited those relationships. And so the employer turned, based on that relationship, and discharged the plaintiff for cause for engaging in an inappropriate romantic relationship with his subordinate. In the court context, the plaintiff admitted to at least one consensual sexual encounter with the assistant at a hotel in Rhode Island while they were traveling for company business. Based on that admission, the court upheld the company's decision to deny enhanced severance under the employment agreement because the plaintiff was in fact discharged for cause, the cause being the material act of willful misconduct of violating the known sexual harassment policy which prohibited supervisor-subordinate relationships. In the next case example, we have the Briggs versus University of Detroit Mercy case, and this is a paramour favoritism case. The facts in this case, if you get a chance to read it, are quite interesting. In this case, the plaintiff, Mr. Briggs, was an assistant basketball coach for the boys basketball team for the university. In addition to him, there were 2 other assistant coaches for the basketball team. One of those other assistant coaches was having a sexual relationship with the athletic director for the university. Now, the plaintiff in this case made what he thought was an anonymous complaint through the hotline provided by the university, where he identified himself as an assistant basketball coach, complained about another assistant basketball coach having a sexual relationship with the athletic director. Now, the court remarked that it wasn't too smart for him to actually raise the fact that, or think that he was making an anonymous complaint, since he was really, after all, just one of 3 assistants. He identified himself as one of the assistants and was complaining about one of the other 2 assistants. So by a 50-50 analysis, it was him or the other assistant that didn't make the complaint. In any event, putting that aside, in the facts that in his internal complaint, he alleged that he was roommates with this other assistant coach when the basketball team was traveling for games, and at the hotel would room with that other assistant coach. But during the sexual encounters that would occur, he'd have to stay out of his room while the assistant coach and the athletic director were engaging in sexual activity. What's more is there's facts in the case where it's alleged that the basketball players, the students at the university, were gathering outside this hotel room in the hallway, giggling and doing whatever else they do these days on social media while the sexual encounter was going on in the room in the hotel. Upon receiving the complaint, the university did in fact investigate the complaint, and both the athletic director and the fellow assistant admitted to the relationship, and therefore the university took action and discharged both of them. The plaintiff was discharged also for other inappropriate activity having nothing to do with romantic relationships in the workplace or having anything to do with his internal complaint. In conjunction with his discharge, he brought many claims against the university, among those being bystander harassment, sexual harassment, and retaliation under Title VII. The court rejected the plaintiff's paramour favoritism claim as sexual harassment actionable under Title VII. The court stated that every other employee with whom the athletic director was not having sex was treated similarly. The favoritism was not based on sexism. Those not engaged in sex, that's not a protected class under Title VII, like gender or age or race or what have you. The court also rejected the plaintiff's retaliation claim. The court found that the plaintiff could not reasonably in good faith believe that he was reporting Title VII harassment. He was not claiming mistreatment based on his gender, and the opposition to favoritism, the court held, is not protected activity under Title VII. And with that, I'll turn over to Denise to discuss the third and final case that we were going to discuss with you today.
Okay, thank you, Don. And if we could have the next slide. I want to talk about a case that has a potentially new type of claim that employees are at least trying to bring. This case involved it was a California case, and we always know that California seems to have as much or more litigation than any state in the country. And this involved an unhappy participant to a consensual office romance who alleged sexual harassment and retaliation against her employer. When the court analyzed her claims, her real complaint was that the employer had allowed coworkers to tease and harass her about her office romance. The plaintiff, a woman named Kathy Alatorre, had an on-again, off-again consensual romance with a coworker who ended up really being her indirect supervisor. Their relationship had predated her employment with the company, and there was some speculation that she had even been hired because of her relationship with a man named Mr. Bergamini. And as I mentioned before, he had some control over her career path. After the lawsuit had been filed, discovery showed that the only complaint that Ms. Alatorre had made via the company's complaint mechanisms was about the gossiping and harassing conduct of her coworkers, who she claimed resented her privileged status because she dated Mr. Bergamini. She admitted in the litigation that she took long walks with Mr. Bergamini during the working day. She admitted she had consensual sex with him away from the workplace, and she admitted she told him on many occasions that she loved him. However, there were some fairly serious allegations of coworker misconduct that were based on their alleged resentment, including the theft of Ms. Torre's cell phone, vandalism to her car, such as keying her car was scraped and keyed, and her tires were even deflated. This is the type of conduct that she complained about the company to. She complained to about the company. The facts established that the company had attempted to manage her complaints and her coworkers' conduct, and had actually moved her away from the coworkers who were allegedly perpetrating the harassing conduct for a period of time until she had voluntarily returned to the department. After analyzing all the facts, the court dismissed all of her complaints. Importantly, for employers, the court made a specific ruling that the law, Title VII, the anti-discrimination and anti-harassment law, does not make an employer liable for failing to control office gossip, or for it imposes no liability on the employer due to the interest of coworkers in an intra-office affair. So while the plaintiff in the action, Ms. Alatorre, had some legitimate complaints The court found she had received nothing but excellent reviews and had never been demoted, passed over for promotion, or terminated, or had her compensation reduced. And the court found that she could not show that her employer had taken any type of an adverse employment action against her, which of course is a necessary element for both sexual harassment claims and retaliation claims. The plaintiff's entire case was dismissed on summary judgment, reaffirming that the one who engages in a consensual romance in the workplace usually does not have a lot of recourse against their employer. So now that we've seen the types of lawsuits that can arise, let's talk about what you can do to prevent a lawsuit in your workplace. If we could have the next slide, please. I'm going to give you the first practical tip. My first tip is that every company should start with a policy, a dating or office romance policy. You can call it anything you want, but it needs to be a realistic policy. Unless you have an extremely small workforce, I think employers need to recognize that people are going to meet and be attracted to each other in the workplace. Analyze whether you really care if someone in one department dates someone in another department, as long as they are both productive and professional in the workplace. And I would submit that these are the types of relationships that you should not try to prevent. I think a realistic policy doesn't try to prohibit all interoffice dating, but only dating between superiors and those subordinates whose career path the superior is in a position to influence. However, whatever your policy is going to provide, whether you choose to allow coworker dating if they're in different departments, or you try to prohibit all dating in the workplace, all policies need to provide that all workplace conduct must be kept professional and courteous at all times. I also think it's a good idea to have the policy address what happens if a supervisor and subordinate become involved. Because in a large workplace, again, even if your policy prohibits it, it is likely to happen at some point in time. Do you want your policy to impose a duty on the supervisor to inform HR if he thinks a potential relationship is about to develop? Do you want the company to be able to transfer one of the participants to eliminate the reporting relationship and avoid favoritism or retaliation if the relationship ends? I think it's best to require the reporting of any supervisor-subordinate relationships that do develop. Again, even if you prohibit them in your policy, you may want to have a caveat that says, if, however, a supervisor finds himself attracted to or involved in a relationship that he thinks could lead to a conflict of interest, that he will promptly notify HR of the relationship and give the company an opportunity to transfer or suggest one of the participants resign. You may even want to require parties to consensual relationships to sign what we call love contracts, which are just nothing more than a writing confirming that the relationship is consensual. But Don will address love contracts in full later on. The key to remember when you're drafting a policy is that you need to keep the working environment professional and productive, and you need to head off any potential relationships that could lead to claims of discrimination or harassment. And typically, these are your supervisor-subordinate type relationships. The next tip I want to give you for preventing liability in your workplace is to train your managers. Every workplace has a lot of turnover in management, and lots of people are very good at their job but not good at managing other people. I know it's difficult to get training organized and to have your managers find time to attend, but I think it's important for managers to understand their role as role models in the workplace, and they also need to understand that a lawsuit can be the end result if they get involved with the subordinate. They also need to know when to involve HR if they see unprofessional romantic relationships developing that are disrupting the workplace. Moreover, training, along with a policy prohibiting sexual harassment in the workplace, helps the company to establish that it took reasonable steps to prevent sexual harassment, which is a defense to many sexual harassment claims that can be brought. There's a Supreme Court case, the Farragher versus City of Boca Raton case, in which the court says if an employer can establish that they had things in place to prevent harassment, such as a policy and training, and they took steps to stop any harassment that they were informed of, then the company has a defense to the claim. So for that reason alone, you can see that it's important for managers to understand what types of lawsuits can arise and also what types of claims, such as sexual harassment and retaliation, can be made so that they can go to HR and the company can take reasonable steps to prevent any harassment which may be occurring. It's a fine line between what is sexual harassment and what is welcome conduct as part of an office romance, and often that's something that starts out as a consensual relationship between a supervisor and a subordinate will later lead to a claim of sexual harassment if the subordinate tries to end the relationship and the manager doesn't want the relationship to end. Sometimes the subordinate will find that their performance reviews suddenly start going downhill, and they may claim it's only because they ended the relationship. The next tip I'd like to mention is to confirm that any reported relationships are truly consensual. If you train your managers and they're hearing lots of gossip or seeing public displays of affection, hopefully they will report the romance or suspected romance to HR or their supervisors so that action can be taken to protect the company. If you're the one making the decision of how to proceed in the light of such a report, I would submit to you that it's usually a good idea to confirm that the reported relationship is truly consensual. If a supervisor is involved, call the supervisor in, meet with them privately, tell them the complaints you've received, and remind him that relationships between supervisors and subordinates are not a good idea. Show him the policy and explain how it can put him in a position where there's a conflict of interest if he wants to continue the relationship and the subordinate does not want to. He or she wants to continue the relationship and the subordinate does not want to. Also explain to him that you require professionalism at all times in the workplace and that he's placed himself in a position for a potential conflict of interest because he may favor his romantic interest or he may try to continue the relationship if the participant wants to end it. If your policy that you've designed for your workplace allows supervisor and subordinate relationships to continue, I would submit that the policy should at a minimum require a transfer for one of the participants so that the supervisor no longer has an opportunity to influence the career path of the subordinate. If they're involved in a romantic relationship, that's just a recipe for disaster. So you need not necessarily terminate people or write them up, especially if they voluntarily report a relationship, but I think you probably do need to try to separate them if they're either unprofessional in the workplace or if one has the opportunity to give performance reviews and or promotions to the other. If you're dealing with coworker dating, perhaps all you need to do is confirm that their relationship is truly consensual and that both parties are aware that there are avenues to report it if they ever believe they are experiencing harassment. Always stress the importance of professionalism at work when you're speaking with any participants in an office romance. You might even want to review your harassment policy with the individuals and let them know if the relationship ends and they feel they're experiencing harassing conduct or retaliation, that they should report that. Also consider having them sign a love contract, as I mentioned earlier, but Don will address in more detail later on. The next practical tip I'd like to mention today is to only address what directly affects the company. Your goals are to keep the workplace professional and to ensure that people are evaluated and promoted based on their merits and not on who they're sleeping with. Peer dating should not concern you if your policy allows it, as long as everyone acts professionally in the workplace. Clearly, if you witness or get reports of jealous screaming matches in the workplace, that is going to affect productivity, not only of the participants, but also of your coworkers, and you will have to get involved and issue discipline or separate people to maintain the professional atmosphere in your workplace. Finally, I think it's a good idea to discourage gossip if people are coming to you and just reporting they suspect a relationship, especially if it involves two coworkers who are in different departments and who are professional at work. If someone reports such a suspected relationship, but it doesn't seem to be affecting the workplace at all, I advise that you just review the company's policy with the person reporting the relationship and suggest that the type of relationship he or she is reporting is not against your policy, as long as it doesn't affect the workplace. You can then thank them for their report and tell them to let you know if the relationship begins causing any problems in the workplace. But this way, you don't become involved if you don't need to. Now, the last practical tip that I want to mention before I turn it back over to Don is that you should document everything, especially if someone comes to you with some type of an unsolicited complaint. I can't tell you how important it is for you to keep a record of that, of who reported it, when they reported it, and what was said. Use it as a basis for discipline if discipline is warranted. But if you receive a report of a relationship, even if it's not currently violating your policy or disrupting the workplace, I would still keep a record of it, because there may be a complaint later on where you do have to take some action, and then you will have a history of several unsolicited complaints. Similarly, if there's a complaint of favoritism, write it down so you can report it to the supervisor who's accused of favoring his romantic interest. And I do think that you probably should advise that supervisor of what has been reported and perhaps question him on whether or not a relationship exists. If you decide to take action and discipline a party to an office romance, such as a supervisor who may be favoring his paramour, it may be important to have a record of the unsolicited complaint to the action you took. It's amazing the creative types of claims that individuals can manufacture when they get fired. I once defended a lawsuit brought by two parties to an office romance who were both fired because of the romance. The woman was claiming sex discrimination and the man was claiming age discrimination. Luckily, she was under 40, so we had built-in comparators for each party's claim. We could prove that we fired her, he was under 40, and we fired him, and he was a man. So we also had a good record of coworker complaints about the relationship, so we were able to dispose of the case on summary judgment without a trial. So it's very important to document those coworker complaints about relationships. You never know when you may need them to help you defend a lawsuit in the future. With that, I'm going to turn it back over to Don, who's going to provide some additional tips.
Thanks, Denise. So the tip number 6, and as Denise has mentioned a number of times so far in this webinar, a policy on sexual relationships needs to be realistic. Outright prohibition of romantic relationships in the workplace is just not realistic. However, as Denise has mentioned a couple times, a prohibition on supervisor-subordinate relationships is realistic, and a policy should contain a clear statement and guidance on these types of relationships. The best practice is to prohibit relationships involving parties in a direct reporting relationship and relationships involving parties who could advance their paramour's career through tangible employment actions such as promotions or raises. As Denise mentioned earlier, if a consensual relationship does develop between a supervisor and subordinate, a good policy would advise the participants that one participant must move to a different position if a position is available, or resign or be terminated. The policy should also address or allow, the participants to choose who will move or resign if business allows that decision to be made by the participants. They should be advised in that scenario that if they are unable to choose who is going to resign or be moved, then the company will make that decision based on its business needs. In the end, clear guidance on these relationships is important. It's important for your management people. It's important for your rank and file employees, I'll call them. And it's also important so that your HR professionals know exactly how to handle these situations when they arise. As a seventh tip, we have here, to advise employees that the company monitors all email correspondence and that they have no expectation of privacy when using company devices, such as company email, company computers, company phones, cell phones, etc. For a long time, employers have had in place both sexual harassment policies, anti-harassment policies, I should say, as well as electronic use policies. And for a long time, these electronic use policies have advised employees, and if they don't, you should have a policy that advises employees of the employer's right to monitor their use of company-owned electronic devices and systems such as email, instant messaging, etc. This right to monitor is very helpful for the company in terms of investigating internal harassment or retaliation claims. The harassment and EEO policies of the company should extend to communications on company devices. Most policies, good policies, will talk about inappropriate emails or texts that have a sexually harassing nature and how those are prohibited under the anti-harassment policy. By having that policy in conjunction with an electronic use policy that advises employees of the right to monitor their usage of devices, companies are well armed to then investigate these harassment and retaliation claims by reviewing the alleged participants' use of their communications and whether they're using those communications in a harassing or in otherwise inappropriate way. But beyond simple monitoring harassment and retaliation, which is generally what we think about when we have an anti-harassment policy, oftentimes you get internal complaints that are more like the paramour favoritism or conflict of interest type situation. And even when you don't have complaints about these relationships, if you're aware of a consensual relationship in the workplace, you still may want to use this right to monitor the participants' romantic or sexual communications through text or email in the workplace, because those communications can take away from their productivity and their performance. If they're engaged in continuous texts and emails about what their plans are going to be that night, or in the worst case scenario when it comes to sexual relationships, you can imagine the types of email communications or so forth. Like Denise has said, I believe that the percentage was 29% of those surveyed admitted to having a sexual encounter actually in the workplace. Well, maybe setting up that sexual encounter it starts with texts or emails through the company devices. So using the right to monitor these devices can go a long way to ensuring that these relationships are conducted in a professional way in the workplace before it even gets to any kind of complaint of harassment or favoritism or anything else that you may imagine with an internal complaint. Moving to the next tip, tip 8 is to implement strong harassment and discrimination policies and consistently enforce them. Now, for decades, employers have known that they need anti-harassment, anti-discrimination policies, and I think most employers today are well equipped to deal with those issues and consistently enforce those policies. As you have been hearing for decades on those policies, you have to strictly follow the guidelines and procedures that are set forth in those written policies, and of course advise employees that retaliation for those lodging complaints under the complaint procedures in those policies is strictly prohibited. In conjunction with those harassment policies, with the next tip, tip number 9, you should consider as a company whether it would be helpful to implement a harassment hotline, a complaint hotline, an internal complaint hotline at your company. Courts have typically found that it is unreasonable for employees not to take advantage of an anonymous toll-free reporting service. By having the hotline, as an employer, you eliminate an employee's claim down the road in litigation that he or she was unable or afraid to report harassment or discrimination. In most harassment policies, your complaint procedure is going to provide for at least one avenue, and a good policy should have 2 or more avenues for an employee to complain about perceived harassment in the workplace. That avenue may be to complain to a supervisor and HR, or may give the employees the avenue to complain to further up management as an avenue to lodge the harassment complaint. But in conjunction with just those in-person complaints, a hotline gives an employee a third option. You know, you have the supervisory chain, you have the HR chain to report complaints through, but you also, this hotline gives them that third avenue. And courts have held that it's unreasonable under that Farragut decision that Denise spoke about earlier. That Supreme Court decision sets up that affirmative defense that if you have a policy in place, you've trained on that policy, and an employee has unreasonably failed to utilize the complaint procedures set forth under that policy, then they're not going, as an employee, they're not going to be successful in bringing their sexual harassment claim. Moving one step lower from these just sexual harassment claims, you could imagine that if you have a hotline in place, employees think everything's harassment, or a lot of employees don't completely understand what is lawful or unlawful conduct in the workplace, and so anything can get captured under this hotline. And so the complaints that we're talking about and the issues that we're talking about so far today involving romantic relationships in the workplace, this complaint hotline could capture coworkers' claims of favoritism, workplace discord, or unprofessional behavior, even though this behavior does not rise to the level of truly unlawful harassment in the workplace. But remember, with anything, whether you have a policy or this hotline, when you have a hotline in place, you must be committed to investigating the claims received under that hotline. That is very critical to the maintenance of a harassment hotline if you choose as a company to move forward with having one. And as our last and final tip for today, and as has been referenced a number of times through this webinar, and no romance in the workplace webinar would be complete without talking about the love contract. And although it has a catchy name for it, you know, these types of contracts are nothing but simple agreements. They can be very simple. They're one-page agreements, and all they do is they set forth in writing that the parties to the relationship acknowledge that, one, the relationship is consensual, and that it does not involve sexual harassment. And also the contract should include a representation that the participants are aware of the company's anti-harassment policy, and more importantly, the complaint procedure under that harassment policy, and that they agree that if a problem arises between the two, that they will follow that complaint procedure in reporting any of those issues. For example, if the relationship goes bad and one starts harassing the other participant of the relationship because they ended it and they want to continue it, and you can imagine the conduct that arises in that situation, that the employee, at least we have this now love contract where the employee has signed a document saying that they're aware of this procedure and that they would utilize it if a problem arises. These love contracts are another way of effectively mitigating the potential negative consequences of known romantic relations in the workplace. But with any good tool, there are those who will point out the drawbacks of love contracts. For one, depending on your workplace, documenting every consensual relationship may become very cumbersome. Also, there are those that state that the utilization of love contracts gives rise to very awkward discussions between employees and HR professionals. And finally, there are critics that say that the use of contracts, or the known use of contracts in a workplace, could drive relationships underground, resulting in secret relationships. However, we would both suggest to you that these risks and these drawbacks that are pointed out by some critics out there of love contracts are far outweighed by the benefits. Love contracts promote openness and communication, the communication that you want as HR professionals to have with your employees. If you know about these consensual relationships in the workplace, you can effectively manage and deal with them. And when things go bad and when litigation does occur, it of course provides a valuable extra layer of protection against harassment lawsuits if they should arise. With that, we're completed with our substantive portion of the webinar, and at this time I'm going to turn it back to Eric, our moderator, for any questions and answers.
Yeah, thanks. Thanks, Donald, and thanks, Denise. So far, I haven't seen any questions come in. Feel free to enter any in the chat box. I'm going to go ahead and go through a couple quick announcements here.